new information in the case of a Massachusetts teenager accused of raping and murdering his math teacher. This got national headlines because of the heinous nature of this crime. A court suspending jury selection in the trial of 16-year-old Philip Chisholm after his lawyer described him as unresponsive and banging his head on the floor of his cell, raising concerns that he may not be competent to stand trial. This is right before jury selection when this all happens, so the timing matters. Rebecca Rose Woodland is a trial attorney. Bob Bianchi is also a trial attorney, as well as a criminal defense attorney and a former head county prosecutor. So just to bring our viewers back, the crime was committed when Philip was 14 years old, Rebecca. He has been in custody since then, awaiting trial. We're at the point of jury selection, and this is when the attorney comes forward along with a psychologist and say, this kid's banging his head. We're going to have to put him in solitary confinement. There's something wrong with him. Is this legitimate, that he's not fit to stand trial, or is this, somehow a distraction?
My question here is, what happened when he was 14? The issue of him being competent or incompetent to stand trial now could be all created. He could be nervous. Sure, he's nervous. But the issue is can they declare an insanity defense, which would mean, did he know right from wrong when he committed the crime? And that is the major issue. Now, of course, they're saying, well, we can't even get to him because he's unresponsive to anything. Well, the judge will see through that, I'm sure.
Do you think because the judge, Bob, is saying, okay, let's go back, I want a little bit more opinion on this, and they've kind of halted the trial so far, awaiting this next decision?
Yeah, this is not an uncommon thing. I was a former homicide prosecutor for many years. The first thing that the judge has to determine is that he's competent to assist his attorney, and there will be forensic people that will look into him, and eventually, if they need to, they'll wait until he's competent to be able to assist in his defense. The thing that I'd like to tell the viewers is that there's a big difference between competency and insanity. Insanity, as was just mentioned, is something that occurs at the time that the crime was committed, where they have to prove that he didn't know the rightfulness or wrongfulness of his actions.
And so that's separate than this diagnosis of what's happening with him.
Completely separate. And when you're looking at the facts of this case with the planning and preparation, what psychologists will do is look what happens just before the crime and just after the crime to assess his mental state, whether he knew it was right or wrong. And when you're dealing with the mask that he was wearing, following her in, going in there, using a weapon, and then disposing of her body, taking her credit cards.
These are all
this is what, just so our viewers know, what he's caught on video, Philip, is following his teacher into the bathroom where this crime was allegedly committed, and then disposing of her body near the school. This is all caught on video, as I just mentioned, but also there was a confession to police, Rebecca, him by himself and then him with his mother, where he wasn't as forthcoming. And the judge says, we're not going to really count any of this in trial. How big of an impact is that, and why that decision?
Well, it's a huge impact on the prosecution here, because the prosecution wants to use the confession. It's a lot easier to convince a jury beyond a reasonable doubt when someone confessed to the killing. The issue here, the judge has found that, well, he wasn't Mirandized properly. He didn't fully understand his Miranda rights. Then his mother came in thereafter, and neither of them understood. Then the child changed his opinion, and as we were talking before, sometimes children do that when their parents are in the room. It's a decision that could go either way, and for sure the prosecution will appeal if he gets off, if there's a not guilty verdict.
Bob, what about that? I mean, is that going to impact? They do have the video still, we should say. The video is allowed, but is this confession crucial to getting him convicted if the case actually goes to trial, which we're waiting to see what's going to happen next?
Yeah, listen, I mean, we've been involved in cases before where confessions are thrown out. The evidence in this case is overwhelming, and one thing that prosecutors want to do when you try a case is not have it reversed on appeal. So if there is any particular problem with this confession, especially if you don't need it, there's overwhelming evidence in the case. That said, I don't agree with the judge's decision, and as it's noted, the prosecutor's reviewing it for purposes of appeal, because he's not saying that his will was overborne or that the statement was involuntary. He was saying that when the mother got there, all the statements made before the mother got there are admissible, but when the mother got there, he kind of puckered up, as we like to say in our world, and he didn't want to speak. But that does not mean that law enforcement overborne his will and voluntariness to give a statement. It's really because his mom was there. Either way, I don't think the state needs it, and with me, I was always very cautious. If I don't need it, I don't use it.
This case goes to a broader question, Rebecca, about how we punish young people in this country. The state of Massachusetts did something interesting and said that if someone is sentenced to life in prison and they're under the age of 18, it's against their rights to keep them in prison for the rest of their lives because they committed the crime so young. This this, again, allegedly a heinous crime. So even if everything goes according to plan with the overwhelming evidence and it goes to trial, Philip would still be paroled at a certain point.
Yes. Now, Massachusetts is trending this. It's something that the very liberal states are doing. They're feeling that a juvenile shouldn't be convicted for the rest of his life, shouldn't find the rest of his life in jail. Now, other states find that no matter a crime like this, no matter how old you are, you face an adult penalty because you created an adult crime. You committed an adult crime and took someone's life. Well, in Massachusetts, they don't see it that way. So he's not facing life or the death penalty.
That's remarkable, Bob. I mean, especially as someone who has tried young adults before. Of course, we want to show compassion where we should. But what do you think about this?
Look, I'm a huge believer in compassion and mercy. But as a prosecutor, when you have an individual, and I've prosecuted juveniles waived up as adult, who have very sinister personalities, very sinister motives, that go and take a razor cutter, follow a woman into a bathroom, slit her throat, take her underwear, credit cards, go out and buy things on them, whatever. These people represent a continuing danger. I don't care how old you are. This kid knew exactly what he was doing, and he's just as dangerous, if not more dangerous, than an adult, and he should be treated exactly the same for a crime like this.
And it was a hate crime as well. Let's add that he used her blood and wrote on her body. This was not anything that happened in the spur of the moment, as they might say, or they might say there was no premeditation. This had a lot of premeditative factors.
It's really a scary case. We would hesitate to talk about some of the details because they're just so gruesome, but all the more reason to talk about crime and punishment and what's fitting, because if he is paroled, it's a problem for the community, not just him and the immediate surroundings. So it's a story we'll continue to watch, and we have another case next hour as well. Bob and Rebecca, great to have you. Thank you.
Thank
John?
You.